And at this time, I will pass over to our speaker, Gordon Holmes.
Thanks so much. I appreciate the introduction and appreciate everyone making themselves available for today's workshop, creating a special needs legal and life care plan. So person-centered planning is the focus for today. Let's see here. Just to confirm, we have in mind this running until when today? Make sure I'm.
We have it running until 3:30. So the last 20-30 minutes for questions.
Great, perfect. Yeah. Okay, wonderful. Thank you so much for that. Just confirming. Of course, the standard disclosure, we're not all things to all people. We try really hard. The importance of integrated planning, creating a life care plan that provides for both the parent's needs and the needs of a child can be overwhelming, making it all the more important to assemble a team of trusted advisors. And this kind of gives a list of of different people that are involved in the planning process. So certainly a financial professional such as myself, a special needs attorney is essential. In some cases, an accountant or a tax preparer, as the case may be, especially if we have a special needs trust or some sort of trust involvement. Bankers, social workers, and advocates like yourselves, and medical providers. So a whole team. So we use the term like my son's name is Matt, so Team Matt or Team Bobby or Team Susan or whomever the case may be. But there are a variety of people from different disciplines that come together to be a part of the planning process. In the journey, depending upon the age, there are certainly different considerations. Prior to the age of 18, Medicaid waivers factor in front and center. The opportunity to get both disability Medicaid for healthcare, whether as a primary or secondary coverage, is important, along with the services available through the Medicaid waiver programs. Generally in Indiana, we don't have a long wait for waivers, which is a real blessing. The situation is not the same in many other states, with people in some cases waiting many, many years for waiver services. Social Security benefits for a minor, and that could be SSDI or SSI, depending upon the parent's situation. SSI is available from birth on up if there's a combination of diagnosis and financial challenges for the family. The Social Security survivor benefit would be triggered by the loss of a parent. I just had a meeting earlier today where a person has lost their father, an individual with special needs lost their father right at the start of COVID. And they're receiving a survivor benefit of approximately $2,000 per month. So that's a monthly Social Security benefit, believe it or not, of about $2,000 a month. And that individual with special needs will draw that benefit off of the parent for the rest of their lives with cost of living increases. And with the kind of inflation that we're seeing now, that $2,000 might be up to over $2,100 by next year. So really remarkable benefits that can come through in circumstances. Again, SSI can start at birth on up with diagnosis and financial challenges. Otherwise, if a parent is retired or disabled, then a minor can draw off of their record that is under the age of 18. If a parent has passed away, a survivor benefit. So a variety of different buckets or wells, so to speak, to draw from, depending upon a consumer with special needs situation. There's, of course, early intervention in the way of benefits. This we in Indiana typically refer to as first steps, and that's birth until the third birthday. So at the third birthday, they age out of first steps benefits, and it becomes the school system kicks in under an individual education plan, otherwise known as the special needs preschool. And so that picks up basically where first steps leaves off. And of course, at that age, a person can look at applying for a Medicaid waiver. The most common, of course, would be the family supports waiver, but it could be a different waiver depending upon the nature of the disability and the needs that the young person has. And then there's further down the road transition planning, usually thought of as 14 to 16, but more practically from 14 until potentially 22, depending upon the academic track that they're on and the services that are needed or are appropriate. Also, before the age of 18, it's helpful to build a legal structure. And this is a combination of preparing for, providing for the child's future, the parents securing estate planning, and so forth. All right. There we go. Okay, and I'm muting my phone to make sure I don't get a ringtone in the middle of my workshop. Okay. So again, speaking of milestones or significant events and or benefits prior to the age of 18, then once 18 and older, SSI kicks in if it has not before. So I'm frequently coaching families on working with Social Security. And if the child or dependent with special needs has not had SSI prior to the age of 18, then usually we're applying for that benefit. And so I help families prepare, in some cases, obtain appropriate evaluations, get testing done, build a portfolio, so to speak, to prepare for working with Social Security toward getting an SSI benefit. Shall we say that, again, inflation has upped the ante because SSI benefits can be as much as $841 a month this year. And we're looking at a potential benefit of $900 plus per month starting next year in 2023. So SSI is certainly very much in demand, but Social Security can make it difficult to obtain and even more difficult to get the maximum benefit amount. So again, working together with families to advocate for their loved one with special needs and get the most in the way of benefits possible. Guardianship frequently focuses in on age 18, in that that's the age of majority in the state of Indiana. And so understandably, as the child is approaching the age of 18, parents will reflect on guardianship. Do they want to secure guardianship? Is it appropriate? Is it going to be helpful? That type of thing. And if they are not going to pursue guardianship, then what alternatives are available? We have looked at that, but guardianship, there's in the state of Indiana, there's partial guardianship, there is full guardianship, And then there are alternatives that include executing a durable power of attorney, a healthcare directive, et cetera. So there are different options with guardianship, and it's a matter of determining what option is best in each family situation. Okay, review of legal structure. So reviewing guardianship plans, reviewing wills, trusts, and estate plans, and what the provisions have been made in the event something happens to a parent. And then looking at Medicaid and Medicare. So Medicare, of course, comes with Social Security disability. And so one will have Medicaid as long as they have a Medicaid waiver and or SSI. As far as Medicare is concerned, Medicare comes with SSDI or Social Security disability insurance or income. And typically after a consumer starts drawing SSDI, it's 2 years and they will become eligible for Medicare. Of course, Medicare eligibility does not mean they lose Medicaid. They can have and maintain both Medicaid and Medicare. Sometimes it's a little bit of a juggle, but it is very possible to have both Medicaid and Medicare benefits at the same time. Employment, age 18 and after. So with employment, there's the SGA or substantial gainful activity threshold. So we have to be thoughtful and careful in terms of hours worked and compensation received if the goal is to hang on to government benefits while being employed. There is the children's disability benefit. And also, and that's when we have a minor of an individual that's drawing Social Security disability. That triggers a children's disability benefit for a child under the age of 19 and still in school. And then there is the disabled adult child benefit, which is typically starting at the age of 22, or actually 19 or over. And that's where a parent has had a triggering event of death, disability, or retirement. Like the case I talked to earlier today, where the young person is drawing $2,000 a month in the way of a survivor benefit from a deceased parent. So you can draw off of a parent by way of their retirement, their passing away, or they're claiming Social Security disability benefits. Okay, and then we're having a record number of people with special needs get post-secondary education, whether it's training of some sort, whether it's academic training or life skills training. But the number of individuals with special needs that are, again, doing some sort of post-secondary education is growing rapidly. I had someone in my office earlier today talking about this. That actually high schools under IEPs are developing programs that are designed to foster employment or life skills training, et cetera. So exciting things are going on. Sometimes they're partnering with higher or institutions of higher learning, such as colleges or universities. I know Vincennes has a program, I think, called AIM. And then University of Cincinnati has a program for young individuals that are trying to learn some life skills and or employment skills, this type of thing. University of Indianapolis inside Indianapolis has the BUILD program for students with special needs or disabilities. You've got Vincennes that partners, in fact, with Du Bois County educators for job skills, life skills, et cetera. You've got Franklin College in Franklin, Indiana, that are working with the autism community on a special program, and the list just keeps growing. So really exciting things happening on the front of both education, employment, post-secondary training, etc. So 10 comprehensive planning steps as a part of life care planning. First is addressing primary issues. So an example there would be, I had a mother in my office this morning at age 76. So the mom is 76. The son with special needs is close to age 50. And she had received correspondence indicating that his Medicaid was to be cut off at the end of May. And with that, she would lose waiver services. And she was a bit frantic. So that's what I call addressing a primary issue. That is kind of the elephant in the room, what is a glaring issue. Really important. And then while we met, we're working on addressing that concern, the concern of the loss of Medicare and waiver services, which is critical in that situation because he is actually receiving care in a waiver home. And so if he loses his Medicaid, he loses the waiver home, and they will release him. And basically, with the mom being 76, he will be back home for her to care for. So, so we always are sensitive, of course, to priorities and crisis situations, et cetera. And then number 2 is to create a life care plan vision. That is, once we can get beyond the crisis of the moment, maybe we can look beyond today or this week or this month and look at creating a vision for the future for them. But exciting stuff is happening these days with individuals with special needs, volunteering, taking on some employment situations, that type of thing, living in the community. Housing options are growing as well. It's just really a very changed landscape from 23 years ago when I started my focus on special needs planning. Number 3, guardianship, alternatives to guardianship, really important there. And depending upon the situation, what, how one wants to handle that. So if one is going to pursue guardianship, then it's important to work with legal counsel. And there are attorneys that specialize in guardianship. And then there are, in situations where there's financial hardship, there are opportunities to secure guardianship at reduced cost or no cost, that type of thing. So really very powerful. The opportunity to get help at a cost that's measured against one's ability to pay. But if one goes to court, you, with the help of an attorney, prepare a petition. It goes to the county court of residence, and then the petition results in a hearing being scheduled. And the subject of the hearing, of course, is the guardianship. If one wants to pursue alternatives to guardianship, there are several options available. One would be, as we mentioned a few minutes ago, to execute certain documents such as a durable power of attorney, healthcare directive, et cetera. In Indiana, there's also what's called supported decision making. So we have several options available based on the individual situation. Identifying financial resources. This is really important. That is, what resources are available, as well as managing resources in order to maintain benefit eligibility. So in some cases, we have to be careful. Social Security funds can accumulate if we're not transferring them each month. In some cases, one's income may exceed their expenses. It's great that we have options available these days, such as ABLE accounts, which were not previously an option. That just came around in the last few years. But with an ABLE account, one can set funds aside and it does not count against them from a resource standpoint. So setting up an ABLE account is relatively simple, and funds can be swept aside in order to be under the $2,000 resource limit required for SSI and Medicaid eligibility. Okay, then prepare the life care plan costs. Depending upon who is working with the family, there may be some cost in putting together a life care plan. A life care plan should include number 6, which is a letter of intent, and a letter of intent is a caregiver guide. That is information that you want to have available to a future caregiver if something happens to parent or parents. We do have a 38-page template that we help families with. You name it, it's in there, from how to get them up in the morning to getting to bed at night and everything in between. So letter of intent is an exciting item there. And then prepare legal instruments. That's the value of working with an attorney, to have your documents all executed and in force. If there is a special needs trust, it should be reviewed periodically, as well as an ABLE account. We enjoy getting families together, so they're mentioning a family meeting there, and then to review and update things as one's situation evolves. Okay. So here are facets of the planning process. We have family assets and planning, balancing needs for all family members, coordinating resources, caregiver planning, employer benefits, life, health, and welfare plans, retirement plans, deferred compensation, and stock. Government benefits means tested benefits, means SSI, Medicaid. Entitlements, on the other hand, are Social Security, disability, and Medicare. Wills, advanced directives, special needs trusts and types, and ownership and beneficiaries all are ways in which we make sure that we've got cohesive planning, who owns what and what beneficiaries are. An example there would be, it's really important to be careful that your child or dependent with special needs does not own an investment account or own life insurance because of the resource limitations, $2,000 being the maximum. Holding title to or accounts being registered in their name can be problematic. Most likely, a bank account or two is all that they will need. But we do have options at our disposal today that we have not had in the past, such as ABLE accounts, et cetera. But legal planning there in number 4. So family is really good when it comes to special needs planning. So hosting a meeting with family and friends can be a great way to approach the planning, especially if you're trying in a very subtle way to recruit individuals, to play a role in the planning process. So share information about the future vision, discuss any concerns and options for future care, and then share news of the special needs trust that you are setting up or have set up for your loved one and how it's being funded. The letter of intent, the caregiver guide, and the teaming approach to care or healthcare. All right, so this gives one a bit of an agenda for that family meeting we were talking about earlier. Okay. A letter of intent is a caregiver guide. And I just emailed that to someone not more than 15 minutes, well, 20 minutes ago before we started. And it is designed to organize on paper, Word document as an example, what information would be very important to a caregiver. So this is a gift that you can create to help someone who's willing to step up and be there for your child. So you can call it an owner's manual. You can make it as specific or detailed as you want it to be. So a lot of opportunities to record and hold information in a letter of intent. All right. Employer benefits. So group life insurance is a common benefit in the workplace. That is, as a result of being employed in a certain location, you may receive life insurance. So sometimes it's a flat benefit amount, such as 20 or 25,000, can be 50,000. But the opportunity to add to the coverage sometimes exists in the workplace as well, where one on a payroll deduction basis can add to coverage. So you may have a basic benefit of 50,000 or one times income, and then you can add a second or third times income, et cetera. So, so group life insurance is a pretty well accepted fixture. Short and long-term disability. This is the opportunity to protect your income, which may be your most valuable resource. So parents especially, we try to make sure that incomes are protected in the event of a disability, because in some cases, a lot is riding on one individual. There may be a mother or a father at home with the child or only working part-time. The key here is to make sure that we have appropriate protections in place, protections against the potential untimely death of a parent, and then also a parent that may sustain a short or long-term disability situation. Employer retirement plans, we of course have so many these days. There are IRAs, there are simple SEPs, 401ks, 403bs, 457 or deferred compensation plans, so forth. So it's a matter of assessing what a parent has, and then for consumers with special needs, looking at that situation in terms of what might they have that would not unseat or affect adversely their important government benefits. Then government benefits. So this divides the government benefits down into two major categories. You have entitlement on the left and public assistance or public benefits on the right. So the entitlement benefits include Social Security retirement income. That is a benefit someone draws because they've paid into the system long enough to be eligible for an income from it. Then there's Social Security disability insurance. And this is drawing a disability benefit. And if a parent is drawing Social Security disability, the adult child may be eligible. If the benefit is otherwise Social Security disability, so you've got your retirement, you've got Social Security disability. These are benefits as a result of someone having paid payroll taxes, meaning it's not welfare, it's paid through the Social Security Trust as opposed to the general taxpayer revenues. So, so there are the Social Security, then family benefits. And, you know, we're seeing family benefits pop up from time to time. In some cases, teachers. There is a survivor benefit for adult children with special needs. There are, in some cases, survivor pension benefits that can be generated. A spouse can be involved. So where one is married, you may have a spouse drawing a benefit. You may have an adult child also drawing a benefit. So just understanding that there are pension benefits and it does impact special needs. Children's disability benefit, we're actually seeing a record number of young people with special needs in the workplace, and at earning about $500 per month in earned income, they're actually accumulating Social Security quarters or credits that can enable them to draw Social Security disability off of themselves. All right, public assistance, SSI, supplemental security income. So that, of course, is a monthly stipend for food and shelter. You're limited to 10 categories of expense involved with the SSI benefit. And so it's trying to assemble, and I have a worksheet that I do provide families in order to help calculate the monthly contribution your loved one with special needs makes to the family situation. As a result of going through the SSI process, then we were able to quantify the contribution that the consumer is making. And then that becomes the basis for applying for or requesting the SSI benefit. The young person can receive the benefit. It can go into a bank account we call a representative payee account. And then the parents can do a monthly transfer out of that account over to their account to reimburse them for food and shelter expenses they're providing for the child. There are some other programs that you may be familiar with. There's SNAP, which of course is supplemental nutrition assistance. There's temporary assistance for needy families, TANF, and then Children's Health Insurance Program, CHIP program. So all programs of public support and help. Here we have, in the case of family benefits, so there is a family maximum, and you can have multiple people drawing off of a single Social Security record. So as an example, a person can retire and draw Social Security retirement benefits off of their own record. A spouse can potentially draw off of them, and then adult children with disabilities can draw off of them. So you can have multiple people drawing from a single Social Security record. Let's see, we've got spouse, survivor, and children's disability benefits. So, with Social Security, the benefits have become so lucrative that one would want to give thought as to when they're going to retire, not just based on their own retirement benefit, but the benefit drawn by the adult child. As we mentioned before, we're just starting to see Social Security benefits in the range of $2,000 a month as a survivor benefit. Again, pretty exciting stuff. So a survivor benefit is typically based on a parent's earning record. And if the parent dies prematurely before retirement, then they're going to show an example. But Rob has 3 children under the age of 18. He's eligible for $2,400 a month in retirement benefits. So that is Social Security. A life event happens. His children under the age of 18 are eligible for approximately 75% of the eligible parent's benefit. So it says a life event happens. If it's 75%, that means that Rob passed away. So if something were to happen, then the child can draw off of the parent's record, and it can be as much as 75% of their full retirement age benefit. Each child is eligible to receive these benefits until he or she turns 18. And then as the child reaches the age of 18 and ages out of the benefit is equally split among the remaining children. So you can hit a family maximum. Family maximum is usually in the area of about 175% of the full retirement age benefit for an individual drawing retirement. But we try to help families make smart decisions, such as, do we want both a parent drawing off of themselves and a spouse drawing off of them as well, along with adult child or children with special needs. So we usually help run numbers and figure out what options are best to take as it relates to Social Security benefits. Okay. Yeah. So if you qualify with a life event, your child with a disability may also receive a benefit after their age 18, based on the parents' earnings record, provided the child was disabled before age 22. So if a child is under the age of 18, then diagnosis is not required. But for a child to draw a survivor benefit or to draw off of a parent's record beyond 18, 19 if still in school, then disability has to be proven. And the parent, well, actually the parent has to draw retirement or draw disability or pass away. We have to have a triggering event. These are the 3 life events you see in front of you. So we have the unexpected death on the left. We have the parent becomes disabled in the center, and then the parent becomes eligible for retirement benefits on the right. So a child can draw, but for an adult to draw, the child's disability has to be documented prior to the age of 22. And then they can be eligible to receive monthly income based on the parent's Social Security earnings record. So pretty exciting stuff, because these benefit amounts are really more than ever. And he may receive up to 50% of his parents' normal or parents' benefit. The amounts vary. So 50% for drawing off of a retirement benefit or a parent's disability benefit. The 75% applies to survivor benefits only. Okay, so Medicare. Medicare is a benefit that typically kicks in with Social Security disability. And so it would just depend upon at what age a young person starts drawing SSDI as opposed to SSI. So with SSI, a person by default becomes Medicaid eligible. With SSDI, they become Medicare eligible. So again, Medicare goes with Social Security disability, and so 2 years typically is the time frame that a person has to be on Social Security disability to become Medicare eligible. So it's not immediate, and usually it catches parents by surprise. So the child may go on Social Security disability because of their own earnings record or off of a parent, but it's not until 24 months later that they become eligible for Medicare. By being careful, they can retain their Medicare coverage while they are, or they can retain their Medicaid and their waiver coverage while they add Medicare to the mix. As a just a suggestion, if someone does become Medicare eligible and they have a waiver, Medicaid waiver, and they, in addition to their Medicaid and Medicaid waiver, they become Medicare eligible, then they're what's called a qualified Medicare beneficiary, and they should not have to be paying for Part B premium against their Social Security benefit. One of my appointments earlier today is being docked, or they are paying a benefit or paying for Part B of their Medicare benefit, and they shouldn't be because they're what's called a qualified Medicare beneficiary. So if you have anyone who is on a Medicaid waiver and therefore has disability Medicaid, and Social Security is charging them for Part B on their Medicare, which currently amounts to over $170 per month, it's quite substantial, then they're paying that premium unnecessarily, as that what Medicare won't pay, Medicaid will take care of. So they don't need to be paying the Part B premium. Medicare should waive that. Social Security should waive that, that type of thing. So you can keep that in mind. The eligibility for the adult child benefit comes with, is what spawns the Social Security disability 24 months later. And we're just listing some of the conditions that can lead to benefit eligibility, such as ALS or Lou Gehrig's disease, end-stage renal disease, et cetera. Okay, so public assistance programs. These, of course, focus on what's means tested. So for someone to have SSI and Medicaid, their resources have to be under $2,000. And so someone needs to pay attention. I had someone in earlier today and they went over that substantially. So the parent set up an ABLE account. We had to sweep funds from the sweep funds out of the bank account over to the ABLE account in order to resolve the resource issue. Again, have to stay under 2,000. It's becoming increasingly difficult to do this with government benefits and income payments rising up a bit. So just be mindful of the $2,000 so that they don't lose their benefits, or Social Security does not determine there was a period of ineligibility and they want the funds back. Medicaid, like SSI, is a needs-based program. Each state, of course, administers their own Medicaid. There are government health insurance programs for specific diagnoses, and Indiana does have that. Covers the cost of certain medical care for low-income people, and children may qualify if parents are receiving Social Security, as we discussed before. There are state waivers. There's SNAP programs, and TANF deals with food stamps and subsidized housing and so forth. You've got your housing opportunities on a discount, so forth. So it's just a matter of looking or assessing the situation. Most of these are means tested, which means if there is too much in the way of funds, then you know you're not certain that they would be eligible. Now, I was asked, I think it was last night, I was doing a workshop, and so prior to the age of 18, a child can be eligible for disability Medicaid and waiver services, regardless of a parent's assets or income. And that can be very helpful. Then, as the child gets older, the parents may be tempted to apply for SSI. And if you apply for SSI once they are 18, then like the waiver, a parent's assets and income are not a roadblock to obtaining eligibility for SSI or supplemental security benefit needs. So at any rate, different programs there. So legal structure and considerations. So suggested items or documents that a person or family should have to help would include preparing a letter of intent. And the letter of intent is a caregiver guide. It's basically the answer to, let's say, what an adult child might cry out if they're slated to be guardian and the second parent has passed. And this letter of intent is designed to provide them with information so they can be a caregiver and not have a horrible learning curve. Or another way to put it is that they may have the thought of what I wouldn't give to have mom or dad, whatever, back for just a few hours to get all of my questions answered. And the letter of intent is the resource to answer all those questions. Okay, so guardianship and alternatives we've touched on already. one would want to try to create a bench, that is to have successor guardians and or trustees. Having a will is important. A will enables you to determine who gets your stuff, who gets your children, and who's in charge. That's just so important, and wills are so inexpensive. Advanced medical directives, those are determining who's going to make medical decisions for you. And then with a living will, how you want things handled in the last chapter of your life. A power of attorney and estate planning are, things that need to be looked at, but a person could have a brief period of incapacity, and a durable power of attorney would enable a spouse or some other family member to jump in, pay bills, and keep their situation afloat. So not having some of these documents can really create tough situations in the event one is incapacitated. Okay, so as far as from a legal standpoint, what happens to your stuff when something happens to you, it's kind of broken down into two different categories. So you're going to have assets that your will address or take care of. So we have wills over on the left. And those assets would include property, checking, savings, automobile or automobiles, furnishings, clothing, etc. So your will controls all of those. Your will controls who the executor is, who's going to be in charge, who you may want to be the successor guardian for minor children or adult children for whom you've gone to court to obtain guardianship. And then you have trusts, and we'll talk about the different types of special needs trusts here in a moment, but also titling of assets, meaning how are the accounts registered? Who owns them? Is there a transfer on death? Is there a payable on death? Is there a survivorship option on the titling of the account, et cetera? So meaning if something happened to one, is it going to automatically default to a co-owner, this type of thing? Are there instructions on it for a transfer on death at the death of the account owner? TODs typically go with mutual fund accounts and investment accounts. PODs go usually with bank accounts and CDs. Then you have beneficiaries on life insurance and retirement accounts. And then you have ownership on property and financial accounts like bank accounts, et cetera. So I know I met with a family earlier today, and between bank accounts, retirement accounts, life insurance coverages, et cetera, there was probably over 25 different accounts, vehicles, just things that will need to be touched as a part of the special needs planning process, because the absence of an estate plan and not having these things addressed can create quite a bit of confusion at the time of death. So let's next talk about special needs trusts. And as I start the conversation about special needs trust, I do want to invite you to ask questions as we're going through this. The chat function is open. All you have to do is click on the icon that looks like a text message and type in your question, and we can start accumulating those toward the later in the workshop. We should go to questions by 3:10. So we've got about 15 minutes or so of material, and then we'll go to questions. And so I'm hoping that all the material that we're covering is prompting some questions. And so I just wanted to invite you to start putting them into a chat if you'd like, so that when question time comes, we can start working on them. Okay, with that in mind, special needs trusts. And right up front is what we call a third-party special needs trust. And a third-party special needs trust is a trust that's funded with monies not belonging to the individual with a disability. So this would be mom and dad's money, grandparents' money, but not money that is owned by the consumer themselves. So, but pretty much you name it, most anyone can contribute to a third-party special needs trust. You can do a GoFundMe fundraising arrangement, etc. People can make gifts, whether family or strangers, but a third-party trust welcomes all money from other than the consumer with special needs. A first-party special needs trust, on the other hand, is specifically designed for the consumer. So a first-party trust can be a godsend when someone does inherit unexpectedly and they have government benefits. It's such an important thing to do, to have these in place as appropriate. So we do third-party trusts frequently when parents want to leave funds for the benefit of their child or dependent with special needs. First-party trusts are usually done when the consumer with special needs has too much in the way of resources. So that's really important to be able to offload excess resources that would otherwise cause them to exceed the $2,000 resource limit and lose these critical benefits. Then there are pooled special needs trusts. So pooled trusts are where typically a nonprofit has a trust, and they invite individuals to participate in the trust arrangement. And that can be very helpful when people are not certain who they could designate as trustee, or sometimes the pool trust is a default trust option if family members that you've put in kind of poop out or decide they don't want to serve. All right, then we have Special Needs Trust Fairness Act. And this is legislation that was passed several years ago that allows an individual with special needs to literally set up their own first-party trust. So it's very cool, but it was a correction to the legislation that was passed many years ago. So, so now a person that has capacity can set up their own first-party special needs trust, stow their assets away in that trust, and then no longer have available resources that block eligibility for these important government benefits. Okay, then we have the Disability Trust, and that's a trust that under the Secure Act would qualify for lifetime stretching of qualified funds, and there are some tax benefits with a disability trust. And then the Miller Trust is when one's total income, earned income, and Social Security reach a point where they're exceeding the amount of income they can have and retain their Medicaid. So this is really important, with survivor benefits reaching $2,000 per month, and with the overarching total income cap being at roughly $2,500, we're going to have more and more people up against the maximum income cap to retain their Medicaid eligibility. And so it's very important to know these limitations or kind of the guidelines, so to speak, so that these important benefits are not lost. So a Miller Trust can be set up, and the income that one is receiving in excess of the monthly amount they're allowed to have can be swept aside into the Miller Trust and then used for other purposes. Okay, so this is a slide on ABLE accounts. I think we have one slide, and so we'll take a little bit of time to talk about ABLE, and then we can go to questions after that. But ABLE accounts have been around since 2014 in Indiana. I think we brought ours to market at 2016, so it took a little while, not too terribly long. And then the ABLE accounts have been enhanced with additional federal legislation, and then most recently, Indiana enacted in the most recent legislature updates to ABLE in Indiana. So we will try to cover all of that here. So again, this started with the Achieving a Better Life Experience, the ABLE Act. The law allows eligible individuals with disabilities who have a tax-free savings account or investment account. It can be invested in mutual funds, that type of thing. It's modeled after 529 college accounts, like our Indiana College Choice savings accounts. Funds can be used to qualify or used on qualified disability related expenses. So it's fairly broad as to how much or how many things an ABLE account can be used for, or withdrawals can be made to pay for things. An individual must be blind or disabled under current law prior to the age of 26. They can be over 26 when they open the account, so they could be 28 or 30 opening the account, not a problem, as long as the disability occurred prior to turning 26. So the origin of the disability needs to be prior to the age of 26, but they can be 28 or 30 or 35 when they open the account. If age criteria is met and the individual is already receiving SSI and or SSDI, they're automatically eligible for an ABLE account. If the age criteria is met, that is, they were under the age of 26 at the origin or beginning of their disability journey, and they're not receiving SSI or SSDI benefits, they must meet the Social Security definition of disability and receive a letter of certification from a licensed physician. So there's a way to be eligible for these things. Maximum annual contribution, 15, actually that went to 16,000 as of this year. So 16,000 is now the maximum as of 2022. And a person can only have a single account. You can't have more than one ABLE account. Each of your family members cannot set up an ABLE account for you. The ABLE account is considered your account, and you can only have one single account. But the maximum has been raised from 15 to 16,000 as to what you can put in an ABLE. And an ABLE account is great to handle a variety of situations. We will look at some of those in just a moment. But the total limit over time that could be made to an ABLE account is subject to individual state limits. And in the state of Indiana, we have a high limit. If they have SSI, they will need to stay under 100,000. If they do not have SSI, but have SSDI instead, then the limit is approximately 450,000. So an ABLE account can have quite a bit, but you're still going to be subject to the annual maximum in terms of getting monies into the ABLE account. Second to last bullet point, if they are employed and they do not have access to an employer-sponsored retirement plan, then they may be eligible to contribute above the annual ABLE contribution. And so you can go higher, again, if you have employment, you have earned income, and you're not eligible to participate in a retirement plan at work. If SSI recipients' ABLE account goes above 100,000, their SSI will be suspended. If they have no SSI, as I mentioned before, the limit for Medicaid retention is approximately $450,000. Okay, before we go to questions, I want to cover just a little bit more on ABLE accounts. And so I'm going to pop out of here and I just thought we'd kind of finish the discussion on ABLE with some examples of, using an ABLE. It can be the unexpected inheritance. It can be a legal settlement. It can be someone who's working that wants to save some of their money. So these are just examples. Okay. Okay. Give me a second. We'll try to get this working. Maybe. Okay. Okay, there we go. So yeah, an inheritance, legal settlement, maybe saving money from an employment situation. Or where one has some resource issues. So if if a consumer is 22, in example one, and has a part-time job, then they could place their income in an ABLE account. It would enable them to stay under the $2,000, but simply putting their paycheck in an ABLE account would not prevent them, their SSI benefit, from being reduced for the income. But ABLE accounts are getting more and more popular. And in Indiana, they're going to get more popular yet. And that's because we're going to have a tax credit. And so within a couple of years, ABLE accounts, as one makes a contribution to ABLE, there's going to be a state income tax credit. That income tax credit is going to be good for up to $500. So at least at this point, we're thinking that it's going to be 20% on the first $2,500 that's contributed to an ABLE. So if you put $2,500 in, then you will get a $500 tax credit, or 20% of the contribution each year. And so that's very recent, but we're looking forward to that. What I have on the screen right now is the lengthy list of items that an ABLE account can pay for. So there's a lot of things that an ABLE account or ABLE investment account can provide for or pay for. So just if you start to think about it, you can see that an ABLE account may be very useful, very helpful. Keep in mind that ABLE accounts do have a Medicaid lien, so the potential exists that upon the death of the ABLE account holder, that the state may seek to reimburse themselves for Medicaid benefits provided them. So, oh well, let's pop back out of that. And back to the presentation here, boom. Okay, and I think I'm still on screen sharing. And let's see if we can go to questions. So again, to ask questions, and this can be questions about anything we've covered in different sessions. It can be about special needs trusts. It can be about government benefits, ABLE accounts, guardianship, anything that you'd like to ask about. And so to do that, if you would be so kind to click on the chat icon that looks like a text message box, and I'll be happy to take questions about anything that we've covered through the series of workshops that we've done. So let's see here. So while we're waiting to see if anyone wants to enter a question, one issue that is coming up is parents getting older, and they're wondering how do they provide for their own care when they're consumed with caring for a child with special needs. And so there are long-term care insurance options available for parents. So it is possible for a parent or parents to secure long-term care insurance and therefore have benefits to meet their own needs so that their own care does not cause a lifetime of savings or accumulation to be exhausted, leaving nothing to fund the trust. So that's one example of questions that come up recently. How can I take care of myself while I'm trying to take care of my child? So long-term care insurance can be helpful. And then also the conversation with a sibling comes up. How do I, how do I get somebody to help be the guardian for child or children? And I often suggest that it's really good to have a plan in place. And So when you reach out to the family member that you want to serve as guardian, you can share with them that, that some planning has been done, and there will be Medicaid and waiver services and very special people doing case management, of course, and that there will also be such things as a funded trust to pay for what the government can't or won't. I think it's just helpful when there's a caregiver guide, there's a funded trust, there are government benefits. It just makes for a much more positive situation if you're focusing on the resources and what you've pulled together to provide for them. We have no questions so far. So any questions from anyone? Either put something in chat, or we have a small group today. So if you care to unmute yourself, then you feel free to speak up and ask a question. I'm just thinking about families that I've met with today and situations that we've encountered today. I met with a family earlier where I met with a parent, and she is a widow. In fact, I've had 2 widows today. Wow, now that I think about it. One was about to lose benefits, and we're helping resolve that situation. There's a way to fix almost everything with special needs. It's how much you know and opportunities that exist. I do see in the chat box is the link for, I think, your continuing or evaluation link to submit that information. We want to make sure everybody gets in everything that they need. Let's see here. Then we had a family also earlier where one of the parents had been involved in military service, had been in the armed forces, and veterans benefits and how they impact government benefits or benefits for a child with special needs. As you probably know, in the state of Indiana, if a parent is a veteran, that accelerates their eligibility for a Medicaid waiver. So that's particularly exciting that one's service as a veteran would accelerate the access to government benefits for their adult child with special needs. Oh well, if there are no questions at this point, I think I'll yield back. We're now at 3:11, so we had the remaining time set for questions. I know we've covered a lot over these various sessions, and perhaps we've handled the questions as they've come up. No questions? All right, thank you everybody for participating. Such a joy to spend some time with you all. We'd be delighted to come back at some point if you want to either revisit topics or look at new topics, that type of thing. I once again want to thank all of you for what you do every day for families like mine that have a family member with special needs. You're just amazing, and I'm so appreciative and so thankful. So I appreciate the opportunity to share. Hope to see you at conferences in person as COVID lifts and we get back to closer to life as we knew it before. If I can be helpful, feel free to reach out to me, email, telephone, etc. Let me know how we can help you as you serve others or help those that you serve. I do have people bring up situations to me where people are seeking answers and need help and are trying to figure it out. So with that in mind, the evaluation link is in the chat box. So make sure to go to there. And with that, I'm going to sign off.
Thank you so much, Gordon. You're always a wealth of information. Appreciate it.
All right. Take care, everyone.
Thank you.
Bye-bye.